A document called a revocable trust is today one of the most widely used tools among homeowners over 60 to protect what they spent a lifetime building. And if you don't yet know what it does, you need to pay attention right now, because banks, probate courts, and even your own children can turn the house you spent a lifetime paying off into a nightmare of months or years of disputes, costs, and delays, right at the moment when you won't be here anymore to sort anything out. And the worst part, most seniors only find this out too late when they can no longer sign documents and no one knows who has the authority to act on their behalf. Today I'm going to show you the 4 benefits this tool can offer to protect you and your family, and the final mistake that makes even people who already have a trust lose everything anyway. Before we continue, hit the like button, subscribe to the channel, and tell me in the comments whether you already have any estate planning in place. A revocable trust works as a legal structure where you transfer ownership of your assets, such as your house, bank accounts, or investments, into a document you create yourself. You continue to be the owner in practice, using and managing everything normally, except now those assets are organized within a structure with clear rules about who takes care of what and when. The word revocable is the key to understanding this. Unlike other more rigid types of trusts, this one can be changed, adjusted, or even dissolved by you at any time, as long as you remain capable of making those decisions. It's not a permanent gift, nor a transfer that immediately strips you of control over what's yours. For many senior homeowners, this structure solves a problem that a traditional will on its own doesn't solve. A will only takes effect after death, and it must go through probate, the U.S. legal process that verifies and authorizes the distribution of assets. A trust, on the other hand, can operate both during your lifetime and after it, covering exactly the period that worries people most. The one where you're still alive, but may no longer be able to manage your own affairs on your own. And it's exactly during that period between being fine and no longer being able to make decisions on your own that most families discover too late that having built an estate is not the same thing as having a ready plan to manage it. The first benefit of placing your assets inside a revocable trust is simple to understand, but it tends to surprise a lot of people. You don't lose control over anything. You keep living in your house, moving money in your accounts, buying, selling, or changing whatever you want, exactly as you did before. This is different from simply adding a child's or relative's name alongside your own on the deed to your house, a common but risky practice. When you add someone else as an owner, they gain real legal rights over that property, which can create problems in the event of debts, divorce, or future disagreements. Inside a trust, the structure works differently. You remain the sole decision maker for as long as you're able to make those decisions. And here's the part that really matters for older homeowners. The trust lets you decide in advance and while you're in full mental clarity who will take over managing your assets if one day you're no longer able to do it yourself. It's not a decision made hastily by others in a moment of crisis. It's your decision, made calmly, documented, and ready to be used exactly when it's needed. This kind of advanced planning is what separates families who get through a difficult phase with organization from those who find themselves lost, not knowing who has the authority to pay a bill, sign a bank document, or simply keep the house running normally. It's this control, kept entirely in your hands while you're well, that forms the foundation for everything that follows in your estate planning. Now imagine a real situation. You go through a serious health problem, a stroke, the progression of dementia, or simply an extended hospital stay. And suddenly, you can no longer sign checks, pay the mortgage, or make decisions about your own house. Without a plan already in place, that's exactly the moment when the family needs the most clarity, and it's usually when they have the least. This is where the second benefit comes in. Within the revocable trust, you've already named, in advance, a person called the successor trustee. That person doesn't need to chase down court authorization or wait months for a judge's decision. They simply step in, following exactly the instructions you already put in writing, and keep paying the bills, taking care of the house, and managing your investments as if it were an extension of your own will. It's important to understand the difference between this moment and what happens after death. While you're alive but incapacitated, the successor trustee manages the assets for your benefit, always following the rules you set. Only after death does the structure move into the distribution phase, transferring the assets to whoever you named as beneficiary. These are two distinct stages with completely different functions, and it's exactly this kind of advanced planning that prevents a lot of the most common conflicts between siblings and other family members. When there's no clear document stating who has the authority to act, it's normal for each child to have a different opinion about what to do. And that can turn an already difficult moment into a prolonged dispute, sometimes even ending up in court. It's worth remembering that the rules around this kind of structure vary from state to state in the U.S. And a revocable trust doesn't automatically replace other important documents, like a durable power of attorney or advanced medical directives. It works best as part of a broader plan, not as the only piece of the puzzle. The third benefit shows up after the homeowner's death, when the revocable trust finally enters the asset distribution phase. At that point, the assets that were correctly placed inside the structure can be transferred directly to the beneficiaries you chose, following exactly the instructions you left in writing, without having to go through the traditional probate process. This changes the family's experience quite a bit. Without this kind of planning, heirs typically have to open a case in court, submit documents, wait for approvals. And in many U.S. states, this can take months, sometimes more than a year, on top of generating legal fees and court costs. With assets properly structured inside the trust, administration tends to be faster and more organized, cutting down a lot of that strain. Take the example of a house. Without planning, the children might find themselves stuck in a probate process, just to sell the property, or simply transfer the title into their own names. With the property properly titled inside the trust, that transition tends to happen much more directly, following what was already decided in advance. And that brings us to the fourth benefit, one that a lot of people don't even realize is at stake: privacy. The probate process in most U.S. states is public. That means anyone can access court records and find out what assets you had, who your heirs are, and how your estate was divided. The terms of a revocable trust, on the other hand, generally don't become public record, which keeps most of that information private within the family, though exceptions exist depending on the type of asset and local law. Putting these two benefits together, the full picture becomes clearer. This isn't just about leaving a house to your kids. It's about creating a structure designed to manage your estate in an organized way while you're alive, and then transfer it afterward with less strain, less cost, and more privacy for the people you love. So far, you've seen four benefits that connect like pieces of the same plan. First, full control over your assets while you're well. Then, continuity of management if incapacity suddenly appears. Next, a more organized succession, without the delays and costs of traditional probate. And finally, the privacy that protects your family from having the details of your estate exposed in public records. But there's one point that needs to be absolutely clear before you make any decision. Having the trust documents signed and sitting in a drawer or a safe doesn't mean your house or your assets are actually protected inside it. This is, without exaggeration, the most common and most costly mistake senior homeowners make. For the structure to work the way it's supposed to, each asset needs to be formally transferred into the trust. In the case of a property, this usually involves recording a new deed in the trust's name, following the exact rules of the state where the property is located. If this step isn't done correctly, the house effectively remains outside the protection you thought you'd secured, and it can end up going through the very probate process you were trying to avoid. There are also situations that deserve extra attention. Properties that still have an active mortgage may require verification with the bank before the transfer. Issues related to taxes, Medicaid eligibility, other heirs with conflicting interests, or even properties located in more than one state can make the process more complex than it first appears. So the biggest mistake isn't simply not having a revocable trust. The biggest mistake is believing it's already working, holding on to that certainty for years, and only finding out too late, often in the middle of a family crisis, that the paperwork was never finalized, and that the protection you were looking for never actually existed. If this video helped you, hit the like button. It really helps this kind of information reach more people who also need to understand their own rights and protect what they spent a lifetime building. And if you want to keep learning about estate planning, homeowner rights, and how to avoid costly mistakes, subscribe to the channel. There's new content every week, made exactly for you.